Quasi in rem jurisdiction. One type of quasi in rem jurisdiction exists when the court has power to determine whether particular individuals own specific property within the court's control. Unlike in rem jurisdiction, however, it does not permit the court to determine the rights of all persons in the world with respect to the property. A second type of quasi in rem jurisdiction permits the court to adjudicate disputes other than ownership based on the presence of the defendant's property in the form infra regarding applicable constitutional limitations. Defendant is not bound personally. The basis of a court's power to exercise quasi in rem jurisdiction is the property within the state. The judgment does not bind the defendant personally and cannot be enforced against any other property belonging to the defendant. Statutory limitations on in personam jurisdiction. Each state is free to prescribe its own statutory basis for personal jurisdiction. Of course, the exercise of jurisdiction in a given case must also satisfy the constitutional requirements. Most states have statutes granting their courts and personam jurisdiction in the following four situations. 1. Where the defendant is present in the forum state and is personally served with process. 2. Where the defendant is domiciled in the forum state. 3. Where the defendant consents to jurisdiction and where the defendant has committed acts bringing him within the forum state's long-arm statutes. Each of these bases of a personam jurisdiction will be discussed in detail below. Physical presence at time of personal service. Most states grant their courts in personam jurisdiction over any defendant who can be served with process within the borders of the state, no matter how long he was present, even if merely passing through. The Supreme Court has upheld this type of jurisdiction, allowing a transient defendant to be served with process of a cause of action unrelated to his brief presence in the state. State law exceptions to traditional rule. Even though jurisdiction through presence at the time of service has been upheld under the Constitution, state statutes and court decisions have limited the power of their courts in certain situations. Service by fraud or force invalid. If a plaintiff brings a defendant into a state by fraud or force to serve process, most courts will find the service invalid for exercising personal jurisdiction over the defendant. While in Tennessee, a driver from Ohio was in a car with a mechanic from Tennessee. The accident was clearly the mechanic's fault, so the driver suggested that the mechanic repair his car and return it to him in Ohio as a means of avoiding a lawsuit. The driver immediately went back to Ohio and filed suit. When the mechanic returned the car to the driver in Ohio, the driver delayed the mechanic long enough to have the process server serve the mechanic with the summons and complaint. The fact that the mechanic was served in Ohio cannot be used as a basis for personal jurisdiction over the mechanic in Ohio. Example, Copus versus Anglo-American Provision Company, 73 MICH 541, 1889. Immunity of parties and witnesses. Most states likewise grant immunity for personal jurisdiction to non-residents who are present in the state solely to take part in a judicial proceeding or who are passing through the state on their way to a judicial proceeding elsewhere. 3. Domicile. Most states grant their courts in personam jurisdiction over persons who are domiciliary of the state, even when the defendant is not physically within the state when served with process. Defined. Domicile refers to the place where a person maintains her permanent home. If a person has legal capacity, her domicile is the place she has chosen through presence, even for a moment, coupled with the intention to make that place her home. If a person lacks capacity, domicile is determined by law. For example, an infant is a domiciliary of the custodial parent's home state. Citizenship. A United States citizen, even though domiciled abroad, is subject to personal jurisdiction in the United States. The scope of this basis for jurisdiction is unclear because states have never attempted to enact laws or rules enabling their courts to obtain jurisdiction solely on the basis of citizenship. Consent. Virtually every state provides for in personam jurisdiction through the defendant's consent. Such consent may be express or implied, or through the making of a general appearance. Express consent. A party's express consent to the jurisdiction of local courts, whether given before or after suit is commenced, serves as a sufficient basis for in personam jurisdiction. By contract. A person can, by contract, give advance consent to jurisdiction in the event a suit is brought against him. An appointment of agent to accept service of process. A person can, by contract, appoint an agent in a particular state to receive service in that state. In an action against him, the terms of the contract determine the extent of the agent power and thus the scope of the jurisdiction conferred. Appointment required by state. When the state heavily regulates a type of business, for example, the sale of securities to protect its citizens, it can require a non-resident engaged in that business to appoint an agent for service of process in the state. Note, the state cannot require every non-resident business person to appoint such an agent because the state lacks power to exclude individuals from the state. However, a state can require non-resident corporations to make such an appointment before doing business in the state. Implied consent. When the state has substantial reason to regulate the in-state activity of a non-resident of the state, it may provide that by engaging in such activity, the non-resident thereby appoints a designated state official as his agent for service of process. Thus, for example, the Supreme Court has upheld statutes that use such implied consent to subject a non-resident motorist to jurisdiction in any state in which he has an accident. Voluntary appearance. A defendant may consent to jurisdiction by voluntary appearance, such as by contesting the case without challenging personal jurisdiction. Generally, any sort of appearance provides a sufficient basis for jurisdiction, but many states allow special appearances through which a defendant can object to the court's exercise of jurisdiction. The defendant usually must make this special appearance by stating grounds for his objection to jurisdiction and his initial pleading to the court. Otherwise, the defendant will be deemed to have consented to jurisdiction. Long arm statutes. Virtually all states grant their courts in personam jurisdiction over non-residents who perform or cause to be performed certain acts within the state or who cause results within the state by acts performed out of the state. In personam jurisdiction, it is granted regardless of whether the defendant is served within or outside the forum, but is limited to causes of action arising from the acts performed or results caused within the state. Unlimited long arm statutes. A few states, such as California, have long arm statutes that give their courts power over any person or property over which the state can constitutionally exercise. These are known as unlimited long arm statutes, limited or Pacific long arm statutes. Most states, however, have long-arm statutes that specify in detail the situations in which their courts can exercise jurisdiction. Limitations in tort cases. Some statutes permit jurisdiction when a tort occurs within the state, while others require a tortious act. The latter language has caused problems where an out-of-state manufacturer puts his products into the stream of commerce, knowing that some items will end up in the forum state. When the gravamen of the complaint is negligent manufacture, some courts have read tortious acts narrowly and confined jurisdiction to the place of manufacture. Others have read it to mean the place the tort occurred, interpreting that to be the place of injury. Interpreting that to be the place of injury. Limitations in contract cases. Many statutes permit jurisdiction if the cause of action arises out of the transaction of business in the state. Some states require the defendant or his agent to have been physically present in the state at the time the transaction took place, but others have taken a broader view. For example, New York has upheld jurisdiction over California residents who made telephone bids from California on painting being sold in New York.